Come back, and still on the highlights of the BBI, the curtains have finally fallen on the Court of Appeal hearing, where the appellants, among them President Uhuru Kenyatta and his handshake partner Raila Odinga, sought to persuade the court to unlock the BBI constitutional amendment process. Duncan Khaemba now revisits some of the key issues and highlights that were made by both sides of the argument during the marathon 4-day hearing exercise.
On which grounds of appeal?
There were grueling, engaging and gripping moments in the appellate court over the past 4 days as the 7-judge bench listened to parties involved in the BBI constitutional referendum appeal case. In their submissions, the appellants faulted the High Court for dwelling largely on legal technicalities at the expense of a process that is purely political and that requires political solution, while respondents stuck to their guns on why the lower court ruling should be upheld for the sake of order and rule of law. The BBI proponents, President Uhuru Kenyatta and former Prime Minister Raila Odinga, argued that any person, including the president, could initiate and promote a constitution change process as long as they could secure million signatures of registered voters to support the initiative.
The record will bear out that at every stage in constitution making in Kenya, it's only when we came together, including politicians and presidents, that this process went ahead.
The people must retain their sacrosanct right to live by the constitution that they chose for themselves and to develop it as they may wish.
The appellants insisted that all parts of the constitution can be amended and it is the people to decide and not courts.
So any issue that would be raised regarding the popularity or the suitability of this bill is an issue that would have been raised to the Kenyan people in the referendum for them to decide for themselves.
Is there any legislation that limits the president from this initiative? The answer is no.
At no point in the whole exercise did the president relinquish his tools of official functions.
On their part, the group of respondents argued that any constitution amendment by popular initiative is a process that should be initiated by a private citizen.
The president is not a mere mortal, he is a superior mortal.
The impugned amendment process must be viewed as a direct product of the handshake.
Civic education should be conducted to provide the public with sufficient information regarding the amendment push. There ought to have been public participation for Kenyans to share their positions on constitutional issues. IEBC ought to verify and authenticate the signatures, a process that should have 5 commissioners on the minimum.
The impugned findings run foul of a subsisting decision in rem of a competent constitutional court.
By-elections are not a matter that the IEBC has to make, requires decisions of the commission on. They are regulated by legislation.
The BBI opponents stated that an amendment push cannot happen unless IEBC has conducted voter registration. The ball is now in the court of appellate court judges, who have the enormous task of either unlocking the BBI process or slamming further brakes on it. Duncan Khaemba, KTN News.